It's a very good question. I love how you asked it because I think that a lot of parents are going to learn from this. Is predetermination of placement by school personnel outside of an IEP team meeting a due process violation? And the quick answer that's going to apply the majority of the time is absolutely yes. And it's a huge violation. Predetermination is a big no-no because it violates more than a few. It's a procedural error that then trickles into a substance violation of the IEP itself. Okay? But then the other thing in between that it violates is a parental right to full parental participation in the process. So it is sort of one of the high cardinal sins. Okay? So that's a huge no-no. So they fully admitted, and this is the thing, when they fully admitted, how did they fully admit? Because this is something that this is why I always encourage parents to make sure that they're recording their meetings, where they're, you got to check your state law. But guys, I believe that you have a federal right to full parental participation. I do believe that being able to record your meeting so you can play it back and understand the process, I do think that you have that right. Now, at the same time, some states, with regards to their allowance on recordings, please check your laws because it's not the same everywhere. Okay, most states, it's a one-party recording state. Others, no. I even know some school districts that are trying to put some kind of prohibition against parental recording, as though the school board has any power, truly over you. They don't. Now, at the same time, I hope that with the current situations that are going on in this country right now, can you guys sort of start to see that, government isn't necessarily your friend and that it's making these rules against you and it's a lopsided relationship? Can you see how it's sort of been hypocritical in what it allows itself to do, but what it won't allow you to do? And guys, it's a disparity in a power relationship. And power relationships need to have some parity with consent involved. And our governments are out of control, starting with our school boards and our local. You want to make systemic change? Concentrate that energy there. We're all in this together, and it starts right there. You want to see changes in your community that's far sweeping, that's going to impact generations, that's where it starts. Don't be looking into some grandiose, you're not going to find the answer there. The answer is local. Why do I know that? Guys, because I fight for all of your kids. And I don't care ethnicity, religion, race, rural, urban, suburban, it doesn't matter. I've seen it all. I've been in it all. I in multiple states, and it's the same exact thing over and over and over again, as Nelly says. Okay? It's one of my favorite songs, by the way. See, I'm going to have that whole, song in my head, and Tim McGraw with his stupid voice. All right. Some of you might like Tim McGraw. All right. So in this situation, when it comes to predetermination, they fully admit, but did you get them on recording? And the reason I ask that is because if you didn't, then a due process, or when they end up getting caught, don't be shocked by the fact that, you'll end up with 5 or 6 liars, okay? And of course, some of these teachers are put in a very bad position where they're threatened with their positions if they don't go along with the party line of lying that predetermination occurred. So that's why I'm always telling parents to watch your 6 and make sure that you have your insurance policies in the form of your recordings and good, concise documentation. that they met ahead before the IEP meeting and reviewed data, not all, and agonized over placement, but they had made the decision and that was that. All right, you're exactly right. And if that's how they did it, then you can undo these kind of things, and they're really not that difficult to undo depending on what ended up happening afterwards. Okay, so let's say you had that IEP meeting, there was a predetermination, you did not agree. What did you do then? Did you write that you didn't agree? Did they give you a prior written notice that said that the IEP that you disagreed with would be implemented immediately? Did they give you a time frame to think about it and file a due process complaint because you did state that you disagreed? All of those things would be things that they needed to do. Now, if they didn't do it, then that's fine. You still have time to file a due process complaint to stop it and implement something called stay put, to where it reverts back to the prior IEP, until this disagreement is ironed out. But everything's contingent upon what that prior written notice says and, whether you complained. But like I said, if it's just a thing to where they ended the meeting and, the IEP, you have it, but it says this and nobody gave you a prior written notice and nobody said you disagreed, well, then you have that time, because the implementation dates would be when that IEP is implemented, and that's going to be in August. So you got some time. You got to move quick though. Okay. Now, if they did give you let's say 10 days to think about it and file due process, and you don't do anything within that 10 days, then that new IEP, regardless of if you disagree with it or not, is going to be the controlling IEP. You can still file due process, and there may be an argument to sit there and still claim stay put status, which would revert back to the last agreed upon. But I'm just saying that that becomes a very gray area with regards to winning that initial argument of stay put. Okay, so these would all be things that you would need to consider. But can they meet before an IEP meeting? Yes and no. All right. Staff talk. It sort of depends on how the definition of that of what went on in that meeting, of whether or not a judge is going to agree that it was a meeting to make that determination. But when it comes to predetermination, if a placement was readily discussed amongst the other members of the team without you present, and there is a consensus sort of feeling everybody out on whether they agreed with it, then yes, that's a violation, and they should not do that ever. Okay, just not. Can they sort of talk about various locations or options? Yeah, they can, but they just sort of can't make that decision. Now, let's talk about one more thing. Now, the reason that we don't talk about location of an IEP or placement of an IEP or where those things are going to be implemented is because we don't talk about where that IEP can be implemented until the very, very end of the meeting. Why is that? Well, because the IEP process is spelled out in all states. Okay? You start with the profile, the child's strengths, the child's weaknesses, the most recent evaluations, establishing baselines, getting parental input. Then the next step, we need to determine transportation needs, whether behavior impedes our learning and learning of others, whether the child needs additional support in non-academic and extracurricular activities. Then we move on to designing goals based upon those baselines, present levels of performance. And then we move on to services. What kind of services are needed so the child can achieve these goals? And what amount of supplemental aids and services are needed in order to support the child achieving those goals? What accommodations are needed so the child can have access to the general curriculum to the maximum extent appropriate for them? See, all of that stuff has to be determined first. And then after putting all of that together, then the team looks at it and says, where And in what environment, in what classroom setting, in what location can this IEP that we just developed be implemented? And so if they already had done this stuff without you, then see, they bypass that product. They went here and they bypass this entire process. And especially if they could have inserted additional push-in services, aid support, staff training, other things in this middle that would have made this environment over here appropriate. And when it comes to least restrictive environment and placements upon the continuum of alternative placements, then at that point, guys, you know, they've got to show a little bit of exhaustion. They've just got to do that. You know, and so you see where if they bypass that and say, well, we're going to send him over here, and we agonized about it, and that sort of tells me that they didn't do this part on potential exhaustion. And the child's home school is supposed to be the starting point. We are supposed to presume competence first and foremost, always in the home school before we start looking elsewhere. Now, I see that you're in Texas, and you know, we practice there, so more than happy to help you out. Like I said, we just need to know that sort of that beginning information, so we know how to navigate and assist you with what you would need to do, you know, sort of ASAP. Okay. But it's all good. I mean, you know, that's what this page is for, is to help guide parents and clarify things, okay, to make you a better advocate for your child.